What does one need to fulfill? What is the criteria in order for this case that the minister has opened to actually be successful?
Well, I believe he's opened a number of charges.
Yes.
And firstly, if you deal with criminal injuria, what you in essence are saying is that the person's dignity was impaired. That I said something that was hurtful, that made him feel the less than a human, it made him feel hurt, it made him feel that his name or reputation has been damaged by my saying the words directly to him. When you talk about defamation, the main difference between the two lies in the publication. To give you an example, if I want to say something hurtful to you and I say it to your face, that's criminal injuria. If I ever say it to a third party or to a media conference and thereafter you hear it or somebody comes and tells you, Kathy, Mario said this about you, that's defamation because there was publication of the defamatory nature that I disclosed. And of course, the incitement to violence basically deals with a person making certain statements which either inflames a group of people, that call a group of people up to violence, and you are in actual fact then inciting violence. And that's in terms of the Rioters Act, which is quite old legislation. So in essence, the three of them would run together in the sense here that you have all three of them in essence dealing with one and the same thing because it's the same allegation, the same words were uttered. In the one instance, it had to deal with the fact that allegations were made about him, the fact that he might be involved, the fact that his daughter, Pravin Gordhan's daughter, might be involved. And all those statements are either defamatory or they are criminal injuria. And the state and the prosecution would probably deal with it in the same vein as well.
So in terms of what the court then actually looks at substantively, are they going to be assessing the legitimacy of the allegations that the EFF is making against the minister and subsequently his daughter, saying that, you know, they've been involved in corruption and state capture? Or will they be looking solely at the comments that were made, let's say, outside of the State Capture Commission of Inquiry, you know, making reference to him and calling him all sorts of names? So what will the court actually be looking at in order to make this determination?
A case would always be proven on the basis of evidence and evidentiary material. Of course, if anything was said in the public domain and it was recorded or anything is available from any of the news stations, then of course you could ask a copy of it and that would serve as proof of what was said. Similarly, if it was said to my face or I ultimately heard it from a third party, you could call that person to come and testify. Or if it was said directly to me, I could testify about it. The fact is, when you make defamatory statements, the only defense against it is if you can say it was the truth and it was in the public's interest. Now, to say that a person, for argument's sake, is a person that's corrupt might be in public interest, but the question is it the truth? So you now, the onus is on you to come and prove to the court that this was in fact a truthful statement that was made. And if it wasn't truthful, it was merely defamatory in nature because you heard some wild rumor and now you're propagating the same rumor, what you're doing is you actually committing the same offense.
So, you know, Slee was telling us that the minister also referenced specifically comments where he was labeled a dog, for instance. So for something like that, the material copy then would suffice as evidence.
Absolutely, absolutely. That should be more than enough to prove the offense. And I mean, how can that ever be the truth or in public interest? I mean, that is pure and simple defamatory. So Julius Malema has a problem because you can't make those statements. You know, it's one thing to say about a politician that this person is corrupted, this person has made renovations to his house which cannot be justified and hence he's infringed the Public Finance Act or something like that. That's fine. But I can't say a person that's being arrested for theft is a thief because he hasn't been convicted of any offense. So until it's been proven in a court of law, I cannot make a statement which I even might believe is true, but it's not the truth objectively.
In a case like this, does the record count at all? So in the case of Julius Malema, does the court then look at the record and say, well, we do have an issue of the Rioters Act that was already brought against him in the EFF. We have perhaps defamation cases that have been handled at the Equality Court. How much of that record becomes relevant, if at all?
Okay, now let me firstly say, when you charge a person with a criminal offense, character evidence as a rule is never allowed, unless you as the accused or your attorney attack the credibility or the character of a witness, you are not allowed to open up the character of the accused. Because let me use a simple example. I might be the biggest crook that Joburg's ever seen, but the fact that I'm the biggest crook doesn't mean to say that I stole your watch during the break. And that's why every case has to be considered on its own merits. So if, for argument's sake, we charge Julius Malema with these offences, then firstly he has to be convicted based on the evidence available at that time. If he's then convicted, then the court can call upon and say, well, listen, I want to now adduce evidence either in aggravation of sentence to show that you have a predisposition to this sort of thing. You're a person that has a propensity of running around and making defamatory statements. But as a rule, unless it's a previous conviction, the court would be loath to just bring in anything for the sake of increasing the sentence.